Hi, this is Whitney Prout, Legal and Compliance Counsel with the California Apartment Association. In this video, I'm going to provide you with a summary of AB 3088, the COVID-19 Tenant Relief Act of 2020. Before we get started, if you're not familiar with CAA, we are the California Apartment Association. We're a trade group representing owners and managers of rental housing in California. We serve the rental housing industry by representing the interests of the industry in legislative, judicial, and regulatory forums, helping our members understand and comply with the law by offering educational materials, forms, and other compliance resources, as well as offering services such as insurance and resident screening that our members need. If you're interested in learning more about membership with CAA, visit our website at caanet.org. In this video, we're going to give you a brief overview of AB 3088. However, it's important to understand that this video will not be providing legal advice. CAA strives to provide accurate and timely information to assist its members, but this information and in this video is only general legal information and is not intended as legal advice. For legal advice about your specific situation, you should contact an experienced attorney. So as I mentioned, we're going to give you a brief introduction and summary of AB 3088 in this video. We're not going to have a comprehensive overview of every provision of the bill because there simply isn't time. This also isn't going to be a webinar that goes into how exactly to comply with the law if you're a landlord. If you want more information about the specifics of this law, you should register for CAA's 1-hour webinar that will cover the law more in depth, and we'll talk about how to register for that at the end. So what is AB 3088? Well, in its most simple form, AB 3088 is a bill that was passed by the California legislature on August 31st, 2020. Among other things, the bill includes new provisions of law to assist homeowners and renters who are struggling financially as a result of the COVID-19 pandemic. Because AB 3088 included an urgency clause and was passed by a 2/3 majority of each house of the California legislature, it took effect immediately upon being signed by Governor Gavin Newsom. In this video, we're going to be talking through the new protections that were created for renters in the bill. We're not going to be discussing the other provisions in the bill. So there are 5 key components to the new law that was created by AB 3088. First, there are the new protections from eviction based on non-payment for renters who have been financially affected by the COVID-19 pandemic. Second, the new law extends existing just cause eviction rules through January 2021 to all renters. The bill also expands the jurisdiction of the small claims court for landlords seeking debts that came due during the COVID-19 pandemic, which we'll talk about in a little bit. And it also placed limited guardrails on the local eviction moratoria that have been enacted since the pandemic began. And finally, the bill also created new penalties for illegal lockouts. So we'll start off by going through those new rules applicable to evictions based on non-payment. Under the new law, renters are entitled to a 15-day notice if the landlord is demanding payment of rent or other charges that came due between March 1st, 2020 and January 31st, 2021. Previously, the law required 3 days notice to be given to the renter. So, under this new law, if a landlord serves a 15-day notice demanding payment of rent or other charges that came due between March 2020 and January 2021, and the renter returns a declaration of COVID-19 related financial distress, which is a statement made under penalty of perjury, then the landlord has to comply by doing the following. First, if the demand was for payments due between March 2020 and August of 2020, then the landlord cannot evict that resident for not making those payments. Second, with respect to payments that came due or will come due between September 2020 and January 2021, the landlord must allow that resident until January 31st of 2021 to make a payment equal to 25% of those payments that they missed as a result of their COVID-19 related financial distress. and they can only evict that resident if the resident fails to make that payment by January 31st. A very important thing to note here, these rules are retroactive. So any 3-day notices that were served prior to this new law taking effect that demanded payments due since March 1st are going to be void and will have to be reserved in compliance with the new law. AB 3088 also enacted changes for the rules for evictions that are not based on non-payment. What the new law does is it extends just cause protections to all renters through January 2021. In short, this means that the landlords must have and state in the notice of termination of tenancy the reason that the tenancy is being terminated. The reasons that the landlord can evict under this new law are generally limited to those same reasons specified in the Tenant Protection Act of 2019, which is more commonly known by the bill that enacted that law, AB 1482, though there are a few modifications. So first, if the landlord is seeking to end the tenancy in order to demolish or substantially renovate the unit, the landlord is only going to be allowed to terminate the tenancy if that demolition or substantial renovation is necessary to comply with health and safety laws. So that's a bit narrower than the general rule under the Tenant Protection Act of 2019. Second, there's an exception from the just cause requirement for single-family home and condo owners who have a contract for sale with a buyer who intends to occupy the unit. And then finally, there's also an exception for tenancies that had already terminated prior to March 1st of 2020. Now, we mentioned earlier that if the resident returns a declaration of COVID-19 related financial distress to the landlord, then the landlord cannot evict the resident for non-payment of those charges, rent and other charges. However, that doesn't mean that the resident does not owe the money. They still owe the money. Instead of being able to evict for it, though, the landlord would have to pursue that money in court. What this new law does is it expands the jurisdiction of the small claims court to allow the landlord to bring any claim for those unpaid amounts that came due between March 2020 and January 2021 in small claims court, even if the amount sought is more than is typically allowed in small claims court, and even if the landlord had previously brought 2 or more claims within the past year. Prior to this new law taking effect, there were limitations that would have prevented the landlord from bringing these claims. The new law also does prohibit the landlord from bringing those cases in small claims court until March 1st of 2021. Now, since the COVID-19 pandemic began, many local governments throughout the state of California have adopted local eviction moratoria. What AB 3088 did was put some guardrails around what local governments could do in terms of expanding those moratoria or enacting new ones. In short, what the new law does is allow local eviction moratoria that are set to expire prior to January 31st, 2021 to remain in place until the end of their term, but does not allow those moratoria to be extended, expanded, or renewed before February 1st of 2021. In addition, the new law also provides that if the local eviction moratorium includes a repayment period for missed rental payments due between March of 2020 and January of 2021, that repayment period is set to begin before March 1st of 2021, then that repayment period start date cannot be extended. If the repayment period start date in the local measure was set to begin after March 1st, 2021, then the new law requires that the repayment period for those amounts must begin on March 1st, 2021. Very important to note that this new law does not limit the ability of local governments to adopt, amend, or enforce just cause ordinances, though local government could not create new mandates with respect to payments that came due between March 2020 and January 2021. Finally, AB 3088 also created new penalties for illegal lockouts. Under the law before AB 3088 was passed, landlords who illegally evicted their residents could be held liable for the residents' actual damages plus a penalty of $100 per day. What the new law does is create an additional penalty that's on top of what the law already provided, and states that landlords who illegally lock out a resident who had provided the landlord with a declaration of COVID-19 financial distress can be held liable for an additional penalty of between $1,000 and $2,500. And currently, this provision of the new law is set to sunset as of February 1st, 2021. So that's a very, very brief overview of the new provisions of the law that were added by AB 3088. To learn more about this new law, visit CAA's dedicated compliance page for this new law, available online at caanet.org/AB 3088. On this page, you'll find resources including forms to comply with the new law, an industry insight that explains the specific of the new law in much more detail, as well as flowcharts to help in your decision making and more. You can also find the link to register for CAA's 1-hour webinar that goes in depth into the requirements of the new law that we introduced in this video, as well as additional provisions of the law that we weren't able to discuss in this video. And again, that's online at caanet.org/AB 3088. Thanks for watching.